Start. However, no straitjacket formula can be laid down except that the observance of time schedule contemplated by Order 7 Rule 1 shall be the rule and departure therefrom an exception made for satisfactory reasons only. Behold that Order 7 Rule 1, though couched in mandatory form, is directory being a provision in the domain of processual law. Full stop para. In view of the above, the provisions made in Order 8 Rule 1 of CPC are directory in nature and the period may be extended by the court in case sufficient cause reason is shown in writing and on consideration the court finds the same sufficient, and if time is not extended grave injustice may be done. Full stop para. Perusal of the application for the condonation of delay along with written statement placed on record reveals that the condonation of delay has been sought in the application on the basis of aberments made in the written statement, but in the written statement no reason or explanation for delay has been given. Consequently, the application for condonation of delay in filing written statement has been rejected. However, the copy of the order sheet dated 4/9/2019 indicates that copy received of plaint is mentioned on margin, but there is no signature or date. So far, the plea of the respondent that the plaint was served with the supplementary counter affidavit filed in RS number 2001 of 2018 is concerned, perusal of which annexed as annexure number CA2 to the counter affidavit indicates that there is no mention of SCC suit number 42 of 2019 in it, and only two annexures have been shown, although copy of plaint has been annexed as SCA. Therefore, it is required to be considered. The application filed under Order 15 Rule 5 of CPC has been rejected on the ground that the revisionist has not deposited the interest of 9% in accordance with Order 15 Rule 5 while depositing the rent with effect from 1/3/2019 to 31st/8/2019, and the revisionist has not disclosed any reason for delay in depositing the monthly rent of September and October 2019, and the representation as provided under rule has not been made. Full stop. However, the revisionist had preferred an application on 3/1/2020 to deposit the rent for 2 months up to December 2019. Therefore, the revisionist has deposited the rent up to October 2019, and he had further given the applications for depositing the rent although the interest was not deposited and there is some delay in depositing the monthly rent. Therefore, it cannot be said that there was complete non compliance of provision made in Order 15 Rule 5 of CPC. Therefore, the question arises as to whether the defense could have been struck off in the facts and circumstances of the case, and because the revisionist has not preferred any representation as provided under Rule 2 of Order 15 of CPC. However, the revisionist has submitted further application for depositing the rent and is rarely ready to deposit the entire dues. The revisionist has also pleaded in his objection against the application under Order 15 Rule 5 that security deposit of rupees 1,80,000 is still in deposit with the opposite party and he is ready to deposit the remaining rent till date, etc.